Good afternoon. This is Leslie Blake from Johannesburg, South Africa. I'm an attorney with about 20 years experience in family law and especially maintenance. And this video is about trying to help you to claim arrear maintenance, because a lot of people obviously are in the position where they haven't been paid the maintenance that they ought to have been paid. At the outset, I can only describe to you the process as it is, not as I would very much prefer it to be. So I'm going to have to tell you that this is not a 5-minute procedure, and this is going to take time and energy from your normal life. Nevertheless, especially if you're owed a substantial sum of money, it is a good idea to proceed with it. And if you start early in the process enough, when the arrears are not that large, sometimes the father who owes you this money realizes that he may as well just give up and start paying regularly rather than end up owing you R500,000 or more, such as some of the matters that I have dealt with. In the first instance, what you need is to download from the internet, from the Department of Justice's website, the following form. It's a pretty straightforward form. There's only 2 pages, and so completing it is not, one would think, the most complicated thing, but you need to do quite a bit of background work before you can complete this form. Firstly, you would obviously need your details and the details of the father and where he is. And then in paragraph 2, it says, the following information is important for purposes of my application. It can be difficult to know what they mean by that. So I'm going to give you a little background on what the court wants you to put in there. Firstly, Section 26 of the Maintenance Act is available to you. You can read it online. Look up Maintenance Act 1998. That's the South African government websites will all show you the South African Government Maintenance Act 1998. And in Section 26, it explains that if you have maintenance owed to you, there are 3 things that you can do to enforce this in civil law. The one is that you can issue a warrant of execution. The second is that you can get an emoluments attachment, which is an attachment on someone's salary or the money that they're paid every month. And number 3 is that you can attach a debt owing to the person who owes you the money. So we'll call him the father for a reference. The father who owes you the money, if he doesn't have a salary, you can't attach a salary. If he is in a position where the salary that he earns is paid by a friend or paid by him to himself, it's not worthwhile to proceed with that sort of thing. Very often, you would then be looking at a warrant of execution. Section 30 specifically says that retirement annuities and pension funds are attachable for maintenance. They're not attachable for any other kind of debt. So this is an only maintenance-based opportunity to catch those arrears and catch those arrears in cash form. And obviously these can be very substantial attachments. So if you are owed many hundreds of thousands, don't despair. There are retirement annuities and pension funds where they will very happily pay that money to you. And remember that he can't spend the money before you get to it, because he's not allowed to spend the money until he retires. So provided the person is under 60, this is a very good option. So in that section 2, what they're really asking you about is, does he have an asset? Does he have a pension fund? Does he have an amount of money that is owed to him, for example, by way of a loan account in his company or by way of debts that are owed to him by someone? All of those things can then be described and explained as fully as possible in that paragraph 2. And if you need more space, you're very welcome to just attach another page to the form. In paragraph 3, it'll ask you about the whereabouts of the person. That obviously means, where is he? How are they going to find him or find the assets? And in paragraph 4, you just asked to explain how these arrears arose. Again, it can be more helpful to set that information out on a separate page. So you fill in the amounts that are required in section 4, but then on an extra page, do a whole affidavit in terms of which you explain how you've arrived at those figures and what amounts were paid and when. I always do my calculation of the arrears in an Excel spreadsheet, because otherwise it's just so easy to make a mistake. And that should have a calculation saying the month an explanation of what was owed. Was it a cash amount? Was it school fees? Was it medical aid? And then what was actually paid, and the balances being brought forward, or one balance at the bottom of all of those amounts as suits you. So once you've got that affidavit and you've got this form filled out, you then need to go and get your bank statements to substantiate that the money didn't come into your bank account or it wasn't paid to the school. So if the money was due to the school, you would need the school accounts. If the money is due to you personally, you also need the bank accounts. And the court requires that those bank accounts be stamped bank accounts so that you're not making up your own PDFs to show that, your bank accounts didn't receive the funds. Once you've got those things, you'll also need your child's birth certificate and, of course, the original of the court order, which was granted to you. And once you've got all of those things together, you go to your closest magistrate's court and with this form, and please make copies of everything, make at least one copy of everything, so that when you hand it in, you keep a copy of what's been handed in, and you make sure that you get your copy stamped to show the date on which they were handed in. You'll usually have to go back and get them to give you back the documents. So the magistrate ought to consider your application in chambers, and then the maintenance officer should come back to you within a week or sometimes 2 weeks or 3 weeks and give you the warrant of execution or the attachment order. And I would always say that you would rather arrange execution yourself, so that you take the documents that have been issued to you from the magistrate's court and you go to the sheriff and make your own arrangements with the sheriff to continue the execution process. You are, of course, if it's a decent amount of money, it's often more worthwhile to go through an attorney who already has an account with the sheriffs, who knows how they work, to get the mechanics of execution against property sorted out. But if you want to do it yourself, you are entitled to go to the sheriff yourself. Best of luck, and I hope this has been helpful.